personal injury or wrongful death claims. Those are in the hundreds of thousands of dollars, at a minimum, and some of them are $1 million plus. So that's really what we're trying to protect ourselves from when we're talking about asset protection. How does an LLC protect anyone from liability?
If you hold property, your investment property in your individual name, you're exposing your life savings, your personal property, all of these things are being exposed to potential loss. You're going to get sued personally.
You're risking $1 million to save $100.
Exactly. Doesn't have to be your tenant. Doesn't have to be their guest. It could be somebody cutting across a corner lot. It's just that easy to get sued. And in today's climate, they'll sue you for anything.
You're listening to Copeland Morgan Media, your source for investment property analysis, education, and advice. Find us online at copelandmorgan.com. Welcome back, folks, and thank you for listening. I'm your host, Jeff Copeland. Our guest today is my friend and Tampa-based attorney, John Redding. John is the founder and managing partner of Redding & Associates, PA, in Tampa. His areas of practice include real estate matters, estate planning, probate, wills and trusts, and title insurance. Mr. Redding earned his Bachelor of Arts from St. Leo College and his Juris Doctor from Stetson University College of Law. Prior to becoming an attorney, John was a commercial title examiner, so he has handled thousands of complex real estate transactions, and he recently authored 2 chapters for the Florida Bar's book, Florida Real Property Sales Transactions, and another chapter for the Florida Bar's book on Florida Real Property Complex Transactions. So he literally wrote the book on this stuff. But before we dive deeper into John's background and expertise, I just want to remind everybody that today's episode is brought to you by Stronghold Training. If you're an aspiring real estate investor, real estate agent, or other professional and you're struggling with wearing multiple hats, time management, lead generation, sales, and you're just overwhelmed and burning out, check out strongholdtraining.com. A wise man once told me that there's freedom in structure, and so many of us just run from task to task without the structure to keep us on track and focused on what's actually important. Tom Perrone at the Stronghold Training there is a friend of the show. He was recently on the show, and I've personally worked with him in the past, so check him out at strongholdtraining.com. John, welcome. It's great to see you again. It's been probably a couple years since you were here in the building, and it's great to have you here at the table with us. How are you? What have you been up to besides the obvious lawyer stuff?
Everything's great. I think I was here when you first got the building.
Yeah, it was kind of our grand opening.
Your open house.
Open house, yeah.
Everything's pretty good, aside from the lawyer thing. That's one of those things.
You can't help that, right?
Yeah, it is. But aside from that, pretty good.
Good deal. Yep. So I understand you got a little disclaimer because we're going to talk about some legal stuff, and people, should take that with a grain of salt, so to speak. So go ahead.
It's one of those things the Florida Bar requires us to do. We have something like this. It's basically the comments and discussion that we're having today is for informational purposes and should not be relied upon as and for legal advice. The viewing of this discussion in no way constitutes an attorney-client relationship. Now that that's said, we can
talk about whatever we want.
There you go.
So my intent with this episode is to focus on asset protection. And for most people, that calls to mind forming LLCs and other entities to create that sort of corporate veil for their rental properties in this case, because we're talking about real estate investors. While I obviously want to dive into that, when I was reading through your bio and stuff and realized how much sort of title insurance history and experience that you have, I was like, wow, we should talk about that. So I want to talk about something even more basic than an LLC. And I think it's one of the most misunderstood forms of asset protection that probably 99% of us already have, and that's title insurance. So what? It's one of your many areas of expertise. Let's dive into it. What is title insurance? Why do we all have to pay for it at closing? And what is it for?
Well, you don't really have to pay for it anymore. Well, you do if you get it, but you no longer are required to get an owner's policy. Ever since Florida accepted the 2006 policy jacket, It's no longer a requirement. So you can opt out of that. Of course, you have to sign off saying you've been advised that you can get this, but you're opting out of it.
And I'm assuming as an attorney, you would not advise people to opt out of title insurance very often.
Absolutely not. I would never advise them to opt out of title insurance. Title insurance is not like car insurance. You don't pay it every year. You don't, it doesn't go up, things like that. You pay for it one time and one time only. Correction. If you refinance, you'll have to pay it again for the lender, things like that. But for the most part, one time and one time only for the owner. Title insurance is a form of an indemnity contract, so to speak. It protects the owner and any lenders from loss resulting in defects in title. Your best title examiner could miss something, so that would be considered a defect. The issue with title insurance is just because the defect is there, it doesn't necessarily mean you have a claim. It means if anybody tries to use that defect, you have a claim. So as long as it's sitting out there in the records, it's not. You can turn it in as a claim; it'll be denied. It's only
So
until
you have to have an actual loss, so to speak, or
the risk of loss.
Right.
So the risk doesn't occur until some action is taken. So if somebody tries to sue to claim their interest in title from a deed from 50 years ago where they didn't convey out, something like that, you then would have a claim. But that bad deed from 50 years ago or however many years ago, sitting out there on its own, isn't doing anything. And it's, like I said, it's a defect, but it has to be acted upon.
Sure. So that example you just described, my Uncle Stu sold me this house 50 years ago, and I still have the deed in hard copy paper. I never recorded it. I never did anything with it, but I now have an ownership interest to your property. That's the title defect that you just gave as an example. Is that more or less accurate?
Not the one I described. You added an extra piece to it, was that you never recorded the deed.
Okay.
So not recording a deed is a different issue. We have, let's say your Uncle Stu passed away in that 50 years. So we now have a problem of you've got a deed that was signed off and delivered and accepted, which is transfers title. Recording the deed doesn't validate it. It just gives notice. And it's evidence of delivery, but it's not a requirement for the conveyance of title. So not recording the deed creates a lot of questions. It talks about delivery. What were you doing with the deed? Why was it still there? What did Uncle Stu really do? So you have a whole laundry list of problems. Record your deeds.
So what I was getting at is that's one example of a title defect. But I'm just thinking of the person sitting at home. Maybe they're a new real estate investor, a new real estate agent, and they're trying to visualize, well, what is a title defect? Why do I need insurance against a title defect? So what I was going to say is, what are some other common examples of title defects?
A missed lien, a missed mortgage, things like that. And those occur frequently. Well, no, not frequently. They're out there. So, like I said, your best title examiner is going to have a bad day. The information systems that they use to get these records might have been misprogrammed and it just didn't pick up that mortgage. It doesn't mean it's not there, but things happen.
Now that you mention that, I have run into this before on a property that I purchased. At some point during the probate and the title, research, they found a mortgage from, 1988 or whatever, that it probably had been paid off, but they had never recorded a satisfaction of mortgage. And of course, that mortgage company had since gone out of business. They didn't even exist anymore. So there was a lot of legal paperwork, I guess, required to quiet that claim on the title.
Well, the legislature's provided some things to cure that. Now, I'll tell you, in law school, they teach us how to go look things up, not how to memorize them. So I can't give you verse and chapter of the Florida statutes where it is. But I can tell you that the legislature has envisioned problems like this and has taken care of this statutorily.
Okay. So, but that's another example of how title defects occur. And obviously, if Old Republic or Fidelity National Title Insurance Company is going to insure the title and say, yes, you have a free and clear ownership of this property, they want to make sure all that stuff is cleared up. And so that's what happens behind the scenes at the title company.
Correct.
And that's why it takes a month to get to closing, or a couple of weeks anyway. It's to do all of this title work and preparation to make sure that the property is conveyed correctly.
Well, I'm glad you keyed in on that. Insurable title and marketable title. The title insurance company, well, first let me go back to when I was an underwriter. I used to tell this all the time to our attorney agents. There is the law, and then there's title insurance. Title insurance understands what the law is, but may require things outside and beyond what the statutes call for. Or they may not in some cases. The case in point, and I know I sent you my bulletin on this regarding tax titles. When you purchase a tax title through the tax collector, and investors do this, if you don't quiet the title to the property, as soon as you put the pen on the paper to sign the contract to sell it, if you're using the FAR form, you are in default because you do not have marketable title. There are still potential claims out there from everybody who held title before that, before the tax sale. Now, because taxes have this heightened level of priority, what you've done with the tax title is created a new chain of title. So you would go in and file a quiet title action, naming all the prior parties, getting them served, taking care of that, and quieting the title over their claims, therefore unifying the two chains of title. So you now have just one chain.
That's a great little nugget of wisdom. If you have bought a property at a tax sale or a tax deed, have an attorney, have John's office look at the title and make sure you have it free and clear and can convey that property without headaches, because you don't want to find this out at the closing table or during the closing process when you go to sell the property 10 years from now.
Well, 10 years from now is fine because the statute requires you to hold the title for 4 years and then it's fine. If you want to sell it...
So 3 years from now.
if you want to sell it anytime between day 1 and 4 years, you should quiet the title. Now, some underwriters have this thing called, I'm not going to use the actual name of the service, but good to close and things like that. And what they're doing is they're going in and making sure everybody was properly noticed with a tax sale. And if they're comfortable with that, they'll then insure the property. Even though it's insured, it doesn't mean you have marketable title. You have what's called insurable title, which is, we'll insure it, sure, it's fine. We'll take that risk. But it's their risk that they're taking, and you don't know about it. So whenever I have a client come to me or a prospective client come to me with this set of facts, I go, you need to quiet the title. You don't have to hire me, but hire somebody. And that's,
And what does that involve? What does a quiet title suit look like?
A quiet title suit, they're all different because you don't know what all's out there, things like that. You don't know what was encumbering the property before, were there code enforcement liens, many of which are still going to be there because they take the priority of taxes as well, some of them. How many mortgages were there? How many judgment creditors were there? Things like that. So what you have to do is serve everybody that would have had a claim, get them all in there, and then get your hearing, get your judgment. You get a final summary judgment, quieting title against all of these things, and you're good.
So you're basically going back and looking for everybody who ever held a lien on this property, whether it was for a mortgage.
One that was still open.
Right, whether it was a mortgage, the city for code enforcement stuff, a contractor, a mechanic's lien, they call it.
713 lien.
For somebody who put on a roof or whatever and didn't get paid. And you have to just make sure that all that stuff is wiped out so that you have free and clear and marketable and insurable title. And those aren't all the same thing.
Right, and you've unified your chain now. It's really easy that way.
Sure. Well, that's it's something a lot of people don't ever really think about. We just let the title company or the attorney's office handle it behind the scenes.
Right.
But a lot of people don't really realize what happens behind the scenes and how all this stuff takes place when you convey title to a property. Speaking of conveying title to a property, I mentioned this earlier. It's kind of I assume the meat and potatoes of asset protection is how do you hold title to your investment properties? And that's all we hear about in real estate investing circles is LLC. You got to hold your property in an LLC for liability protection. First of all, why is that? How does an LLC protect anyone from liability? And then secondly, why is that the prevailing wisdom in terms of holding your properties in an LLC? And is that always the right move?
It's one of the moves. You could hold it in a corporation if you wanted to. You could put it into a trust if you wanted to, or in an LLC. I think the reason why everybody goes with the LLC is because they're very easy to manage. They afford you the same protections as a corporation, and they're more simplistic. You have an operating agreement that tells you how to run the company, not the business, and you're good. You have your annual meeting and everything's fine. You don't have all the requirements that a corporation calls for. You don't have all of the just management nightmares of a trust. And I get asked to do trusts all the time, and I literally shoot myself in the foot and talk people out of it. I go, no, let's do something else. So the reason why you do that is if you hold property, your investment property, in your individual name, you're exposing your life savings, your personal property, all of these things are being exposed to potential loss. Say somebody walks across the lawn, steps in a gopher hole, and breaks their ankle. You're going to get sued personally. I always tell my clients, if you have multiple properties, have a holding company LLC, and then have another LLC beneath that holds title to 3 of them, another LLC over here that holds title to 2 or 3 more, things like that. So you actually have 2 different steps in front of you. If you only have a couple of properties, one LLC is fine. The only thing you can't do with the LLC is you should never have a single member LLC. There's ways that they can be pierced. You want to make sure you don't use the LLC for your wallet. You pay yourself first and then do whatever you want to do after the fact, but don't go writing checks to your tailor out of the LLC account. You just can't do that. There are defenses to it. I don't practice in tax law, but there's defenses to doing that. There's ways around it, but it's just not recommended.
Sure, and that's a great point. That the listeners out there who have an LLC that have their rental property in it, it's very important to keep those books completely separate from your personal sort of operating funds. And,
exactly.
I mean, there are legitimate expenses. You can have business meals, you can have travel,
absolutely,
and things like that. But like you said, don't go buying a pair of sneakers with your LLC account, because now you're mixing your personal stuff with your LLC stuff, and that just makes it that much easier to claim that there was no veil of protection.
And there's things they can discuss with their tax preparer of their choice, and the tax person will be, or their CPA, et cetera, will be able to tell them what they can and can't do and what they can assign to the LLC, et cetera. And that's a whole different show. Get a CPA in for that.
Well, that's a great point, because what I have found over the years is if you ask an attorney the question, they'll tell you A. If you ask the CPA the question, sometimes they tell you B. And then sometimes if you ask, your mortgage broker or your insurance agent the question, they'll tell you, you can't do A or B, you got to do C. And so it can be kind of a confusing matrix for real estate investors, especially when they're newer. And I know one of the things that can potentially get people in hot water is everybody wants to buy a property with conventional financing because you get a 30-year fixed rate. But your mortgage person is going to tell you if you want to use conventional financing with a 30-year fixed rate, that's a personal product. You have to do that in your personal name. So they buy the property at 123 Main Street in their personal name. They get the great financing terms. And then everybody and their brother tells them, hey, after you close, just go put it in the name of your LLC. It's no big deal. Now, there are situations where it can be a big deal and it can cause you trouble or problems. What are some of those?
Well, first and foremost is this really nasty thing called a due on sale clause. And I've not seen any conventional mortgages that didn't have one. There may be one out there, I just haven't seen it. What the due on sale clause does is when you sell the property, and if you look at the language on the deed, it's grant, bargain, sell, and convey is the standard language used. That's technically a sale. No cash need change hands to make yourself a purchaser. You just moved it over. There's a whole different set of things we could talk about, but let's talk about this part right here first. So you've moved it into your LLC. Chances are the lender's never going to know because they don't go searching public records. They don't check the tax rolls. They don't check the property appraiser. As long as their payments are being made, chances are they'll never know. If they do, you need to get a hold of somebody other than the person that wrote you the letter or the form letter that says to call them, because you need somebody who has decision-making abilities. And what you need to do is tell them you did that for estate planning. The beneficial interest hasn't changed and there was no sale. And that should work. I can't tell you it won't. I can't tell you it will. I've never had to do it, but that's what I tell people. Okay, if you want to do this, these are the risks. If this happens, this is what we can do. Can't guarantee that's going to work.
And so just to recap that, the due on sale clause in your mortgage basically says if you transfer title to this property, which you pledged as collateral for your loan, it's due on sale. You owe us your full mortgage balance within 10 days or whatever it says.
Whatever it says, you the whole shebang.
And so by transferring title, you can ultimately owe your lender the full mortgage balance if you don't do it, or if you don't do it correctly. And I know one of the other problems you can create, and sometimes this is how the lender finds out, is, well, if you transfer title to Acme LLC and your insurance policy is in Joe Smith, your personal name, well, now Acme LLC owns the property, but they don't have an insurable interest in the property. And so there's the possibility that the insurance carrier says, you don't even own it. How can you insure it? And usually your mortgage company is a named insured, or at least what's the other thing called?
They're a non-contributing beneficiary.
Yeah, and so they get notification that says, hey, John Smith dropped his insurance on this property, and that's what triggers them.
The lucky thing about that is that usually the left hand doesn't know what the right hand's doing at these lenders, and the other departments won't communicate. They just say, yeah, we got a policy for this address, good, we're fine. Not that it couldn't happen. A way to try to get around that would be perhaps to make sure that you're individually named as a non-contributing beneficiary under the policy as well. That shouldn't cost you any additional funds.
Yeah, that's a good point. Just name yourself as an additional insured on the policy,
Right.
and now the LLC and you have an insurable interest in it. So you mentioned there were some other pitfalls. What are some of those?
Well, back in Florida, we used to use the Form 1998 policy jacket and commitment for title insurance. And back then, you could convey the property and still be an insured if you used the proper type of deed. And here, if you used a quitclaim deed for that, that's not the proper type. That would bar your ability to claw back under the warranties of the deed to get to the title insurance. In 2011, Florida being the last state to accept it, has adopted the ALTA 2006 policy and commitment jackets. Now, we're about to go to the 2021, probably later this year, but that's a different show. Under the 2006 language, it changed what an insured was. So if you take title to the property through legal process such as a probate, something like that, you're technically an insured. But if, say, I don't know, a husband goes out and buys the property 2 weeks before husband and wife get married, and then for some reason never conveys it over to her, 20 years later he decides to go ahead and put it into them together, and then he passes away, she's not an insured because under the language of the new policy, that's taken her out because it wasn't by operation of law, it was a conveyance. And like I said, the standard language on the deed, grant, bargain, sell, convey, makes you a purchaser under the 2006 definitions.
So in this case, we're not talking about homeowners insurance, but we're talking about you can sort of write yourself out of the benefits of the title insurance that you paid for.
Correct.
If you don't transfer that deed correctly.
Well, even if you do transfer that deed correctly, there's a there's a trial level case that came out, I think it was 2015, the Ray case. I'm not sure which county it was in, I think it was Lee. But it addressed these exact set of facts that I just talked about. And the court came back and basically said you're not insured because you are a purchaser. Whether any cash changed hands or not, it doesn't matter. You fit the definition. That went up to the appellate level. It was per curiam affirmed, so there was no written authority, but you had to go down and dig into the lower level court to read about it. But I will tell you that the underwriters that did it, they know about it, and I used to be an underwriting attorney myself, and I know we all talk, so it's out there.
So in that scenario, you'd have to buy a new title insurance policy.
Have to buy a new
There's
policy.
no right way to convey the deed without having to purchase new title
Right,
insurance.
there's no way around that. It's just whether or not they catch it, whether or not they know about it, and I'm pretty sure they all do.
Well, and I see this all the time, and I think a lot of real estate investors are really kind of willy-nilly about, I'm just going to do a quick claim deed here and then do this and do that. And I always tell them, hey, whoa. There's usually almost no reason to do a quick claim deed. You can always just do a special warranty deed, and it conveys much more benefits. And oh, by the way, don't download some form from Google. It's not expensive. Go pay an attorney to do it correctly according to your state laws, because there's so many things you can screw up if you do the deed wrong.
Correct. I always tell people that the funds you would pay the attorney, whomever it may be, to prepare whatever document you need done would probably cost about a third of what it's going to cost to fix what you did with legal doom, as I call it, or Google or something like that. It's just too important not to get it done the right way.
That's a great point. And so don't think you're saving money by a DIY deed transfer. It's just not worth the risk. So I recently did an episode with Mike Tonsatich from Blanchard Insurance, and we talked about how, on the homeowner side, a roof claim or a water damage claim is typically tens of thousands of dollars. Your roof might be $10,000 if there's some litigation involved, but maybe it's $100,000, whatever. A water claim, same. You might have a $10,000 floor, or maybe it does your whole house and it's a $100,000 claim. But that's really nothing compared to when we start talking about personal injury or wrongful death claims. Those are in the hundreds of thousands of dollars, at a minimum, and some of them are $1 million plus. So that's really what we're trying to protect ourselves from when we're talking about asset protection. I mean, of course, your homeowner's insurance protects you from property and casualty damage, but the real big risk is that wrongful death or personal injury claim that happens on one of your properties.
Correct. That ties back to the person stepping in the gopher hole.
Yep. Or the person falling off the roof and dying. Now you've got to...
Well, that's why whenever you have anybody up on the roof, you want to make sure that they're properly licensed and insured.
Oh, absolutely. You're preaching to the choir here. As a property manager, don't ask me to put a handyman up on your roof to fix your flashing or something. You're just asking for a lawsuit.
The money you save having a handyman do it, you might lose when he falls off the roof.
You're risking $1 million to save $100.
Exactly.
But where I was going with that is, let's talk about insurance, especially liability insurance, which, since liability is what we're trying to protect ourselves from, and umbrella policies in particular. How much liability insurance is enough, and is transferring that risk to the insurance carrier, is that adequate if you can't or don't want to, for whatever reason, put the property in an LLC?
Well...
And before we jump into that, I just want to point out that just because the property's in an LLC doesn't mean you don't have any liability. It just means your liability is limited to what that particular LLC owns.
Correct.
And so that doesn't mean you're not going to have $1 million claim. It just means they're not going to be able to come back to your personal assets, your personal bank account.
They're not coming back after your life savings, et cetera. Right. They're going after the assets that are there for the LLC. That's why I always tell people, don't put too many properties in them.
Sure. So what are some insurance best practices from an attorney's standpoint?
From an attorney's standpoint, insurance is a risk avoidance tool. You don't have to have insurance. I think you're a fool if you don't.
Well, if you have financing in place, they're going to make it. But otherwise, nobody's going to force you to.
Your home, say you bought it as a home, and then you have been making some good investments, and you want to lease out what was once your home, and you've bought this really palatial place somewhere else, and this is kind of cool, You're digging it, but you've got your old homeowner's insurance policy, and you think you're really covered there, but you're really not, because it's not your home. It's no longer it might have been for a while, but it's not now. You need a different type of policy. Again, I can't quote the actual numbers and letters for this policy because
I just learned this last week. It's a DP3 policy for the landlord versus an HO3 policy for the homeowner.
There you go. Thank you. I have to, again...
bonus content.
Again, they teach us in law school how to look things up, not how to memorize them. But the difference is you're not protected from the guy stepping in the gopher hole, the guy falling off the roof. And that person stepping in the gopher hole doesn't have to be your tenant, doesn't have to be their guest. It could be somebody cutting across a corner lot. It's just that easy to get sued. And in today's climate, they'll sue you for anything.
Yep.
So you really want that insurance standing in front of you to protect you.
And the other challenge is most homeowners insurance policies in Florida have a $300,000 liability limit. And a lot of maybe newer investors or people who haven't sat down and planned this stuff out they may not even know what their liability limits are. It could be lower than that. $300K is usually the max they'll give you. And if you've got a $100,000 liability limit on your rental property, you need to talk to an insurance agent and protect yourself at a higher level.
And that's where the umbrella comes in. What you want to do with that is have an umbrella covering over the other policies so that you've got an extra tier of protection.
Absolutely. So you mentioned earlier trusts. In my mind, a trust is more of an estate planning tool, not an asset protection tool. But I might be completely wrong. So
it's both. It's both. It works just like, well, it doesn't work like the LLC. It does the same things as the LLC as far as standing in front of you, protecting you. You draft a trust that has what's called a spin-thrift provision so that they can't attack the trust assets for a judgment against somebody individually, because it's not his money or her money until it's put in their hand. Once it hits their hand, they can come after it. But when it's over here in the trust, it's the trust's money. So there's those protections. An LLC, whenever I write the letters to my clients, when I spin their properties into an LLC, I call that estate planning. And if I ever have to deal with the lender, that's what I'm going to call it there too, because they didn't want the cumbersome nature of a trust, but they wanted it done a different way. They wanted to take it out of their own personal assets, so it's not something that's going to get probated. The ownership interest in the LLC may be is probatable, but the properties are still there.
So when is a trust appropriate and when is an LLC appropriate? There are different tools for different jobs. Obviously, I'm just trying to clarify in my head what are the two different jobs that those tools would be used for.
You can use them for the same tool, like I just said. The trust, a lot of people saw that late night TV show and order the book, and I need a trust. Most people don't, and the reason why you would have a trust is if you have a potential heir, son, daughter, nephew, somebody you're going to in a line to inherit from you that has a gambling problem, a drug problem, things like that, where they can't inherit a chunk of money, and you want to have the trustee take care of them and pay for their living expenses and things like that. You would have a trust for that. You wouldn't have an LLC. And in that respect, the trust is an estate planning tool. The LLC doesn't do that. The LLC doesn't have a trustee or somebody sitting, okay, let's go pay Johnny's rent and buy him groceries. They don't. That's not there. But as far as taking things out of probate, things like that, it can be used for that as well.
Sure, but that's a great point about the trust. And now that you mention it, of course, I knew that because we have a trust for our assets, and mainly because my kids are 18 and 21. And, you don't want to give a 21-year-old the keys to the kingdom. And that's why you would have a trust. Somebody that you don't want to inherit that much money. Yeah, we have a trustee who's kind of a trusted third party and, and kind of left her some general guidelines. Like, hey, my kids are smart and reasonable, but at the same time, they're in their 20s, and they're 18, 20, whatever. Well, I mentioned drug use and gambling. I didn't mention the disability of age, but that's absolutely. Yeah, you don't want to give teenage boys the keys to the kingdom. No. And you want them taken care of, but you want to make sure that it lasts, And I think 25 is a more common age when they sort of age out of. I don't think I grew up till I was 35. Well, me either, but most 35 and 40-year-olds don't have a trustee still controlling the purse strings. So you touched on estate planning. You obviously do that too. What can real estate investors do as far as estate planning is concerned to make things easier on their heirs from a probate standpoint, from a tax standpoint? How can we, as real estate investors, make that easier on our kids or our other heirs? Well, I can't comment on tax. I don't practice tax law, and quite frankly, I have a great CPA. Get one. But as far as making things simpler, taking things out of probate, putting it into a trust would be one way to do it. They're just cumbersome and difficult to deal with. You appoint a trustee. They're kind of hard to get rid of. You can do it, but if you have to, you've got to go into the courts to get it done if they don't choose to be removed, things like that. So you have that issue. Say, you have your trust and you have a trustee and a successor trustee appointed and named in the trust body itself. What do you do if both of them pass away after you're gone? Because after you're gone, the trust can't be amended. If it's an inter vivos trust, it can be amended and revoked as long as you're alive. But once you're gone, that's done. Here's the trust. You're stuck with it. So you've got to go into the court system and have things done that way, and there's where it's cumbersome.
With the LLC, when your kids get to be a certain age and they're responsible now, you could make them members of the LLC as well and set out in the operating agreement what happens.
Yeah, and that's an interesting point, and it's something that I know you and I will be talking about here in the next couple of weeks because we're doing some of this stuff. But if you have adult children, but maybe they're still dependent children. In my case, they're 18 and 21; they're college students. But it might make a lot of sense to make them members of my LLC, or at least that's one option we can discuss, because that makes, if something happens to me and my wife, well, nothing really happens to the company. The ownership is still there. The LLC still exists.
And
Nobody misses a beat.
There's still members. The LLC still functions, things like that. The membership interest is a probatable asset, but as far as the LLC functioning daily, the property is being managed and taken care of, that's still happening.
Right. Yeah, so that's a great point that probably a lot of people don't think about when they create their LLCs. Well, what happens if I die? Now there's this business entity out there with nobody at the helm.
Right.
And that's why you want to talk about multiple members and sort of an order of succession, I guess you would call it. So if I am an aspiring real estate investor and I'm sitting in Cincinnati or Detroit or New York or California or whatever right now, but I've got my eyes on Florida. I want to buy an investment property in Florida. As an attorney, as their attorney, where would you tell them to start? Do you buy the property first and then create the LLC? Do you create the LLC first and then start shopping for property? What are some best practices for a new real estate investor? I'll leave it at that.
Good question, and there's a lot of facets to that. I would always recommend having the LLC first. It just makes things simpler. If you're buying it for cash, that's the best way because you can put it right in the LLC and not have to worry about a lender. If you're going to go ahead and do conventional financing, they're going to require it be in your individual name, and we've already gone down that road. So having the LLC set up first just makes it quicker to move it into the LLC to protect your assets. The problem we have right now is the Secretary of State is behind on filings, and I had one take 2 months.
I was just thinking that as you were talking, if you go under contract on a property and then think, I'm going to create an LLC real quick, it's probably not going to be ready in time for closing because the state is running about 6 weeks at the moment.
And this is even with using their online forms, which I don't personally use. I use my own because there's things I just don't think I want people to see, at least for that first year. But that's not just saying by using my forms takes longer. It's just that's what it takes right now. Even if you use their online forms, it's going to take about 6 weeks.
Yeah, like every other organization out there, people are working from home and everything's taking longer with the state of Florida.
Yep.
So that brings me to a couple of closing questions, unless you have any other thoughts on asset protection or estate planning.
No, I think we covered a lot of it.
We covered it quickly, but we hit the highlights for sure. So where do you see the Tampa Bay real estate market going for the next few years? And I think you have an interesting perspective on this because you do real estate closings as an attorney. You kind of see the comings and goings at the closing table. It's
interesting, and I have a lot of friends at different firms as well, and some of them that do foreclosure work. And I'm seeing that foreclosures have come back.
That's interesting.
I expected, everyone was expecting the market to do a crash in November of 2020. Well, we had the pandemic hit, and we had all of the protections for tenants, things like that, so they weren't paying rent. So that naturally threw mortgages into default for, the people that came down here, bought 3 houses, used that for their retirement and had them rented out, and everything was good when the rents were being paid. Well, now the tenants think they don't have to pay. So you have that issue, and those have gone into default. Things like that have happened. I don't want to say that we're having the same problem we had in 2007, 2008. I don't suspect it'll be that bad, but I think we're going to have a market correction. We have in my opinion, inflated prices right now. It's crazy. You put a sign up, and the house is sold in a day. Well, you know that.
No, I know it all too well.
And that's great for realtors. It really, really is. But as far as for the buying population and the selling, it was great for the sellers. But for the buyers out there, it's a little difficult right now. But I do see a correction coming.
Yeah, and At some point, I don't know when, and nobody knows when, but I also want to point out that a correction is not a terrible thing.
No.
Slightly lower price points, more inventory to choose from, those would all be healthy for the real estate market right now. It's a tough market to do business in right now because there's not a lot of stuff for sale, and the stuff that is for sale, even if you're the listing agent, it's no fun taking 1,000 phone calls and getting 50 offers in 2 days on a property. That's a lot of stuff to
a lot to process.
through. That's a lot of work to do, and so. I could envision sort of a tapering off. No, I wouldn't say the word crash, but sort of a leveling off.
That's why I think it's going to be a correction.
Yeah, leveling off and more reasonable, more sustainable growth. We can't do 20% year over year over year over year over year forever.
Right.
But we can do 5-10% appreciation,
which was normal.
Yeah. And then my final question: what's one tip, trick, tool, or some words of wisdom you'd share with that aspiring real estate investor or real estate agent? And what's something you wish you had known about real estate 10 or 20 years ago?
It's kind of funny. 10 or 20 years ago, well, a little more than 20 years ago, I was a commercial title examiner. And we used to always say, if you wanted to mess up a deal, get a lawyer involved. That's just not the case anymore. And I'm not just saying that about myself. Hire somebody. It doesn't have to be me, but pick a lawyer out there. Make sure that they're involved in real estate. You don't want to get a guy who is who practices a number of different fields. Get somebody who's concentrated in real estate. They don't just specialize in it, but we can't use the word specialize unless we're, board certified. But and I'm not. So concentrates in real estate. Because there's too much going on out there. The title agent can't give you advice. Your real estate agent does a phenomenal job, but they can't give you advice. That's the unlicensed practice of law, and you shouldn't be asking them to do that because you don't want to get them in trouble. Everybody has their function in the real estate market. And I think having an attorney on your side from day one to review contracts, to look things over, make sure they haven't marked something out, make sure they didn't sneak something in. Have your attorney sneak their own stuff in. You've seen my contracts.
I have.
There's a lot of stuff I add. A lot of stuff I take out.
A lot of red ink.
Yeah, a lot of stuff I strike out. But you want to make sure that that's taken care of. We have the contract, the FAR contract's a fair contract. But like any contract out there, it's got its problems.
And for those that don't know, it's the FAR is the Florida Association of Realtors / Florida Bar Association. That's what we refer to as our standardized state contracts that most real estate licensees use. We refer to them as the FAR. And there's a few different versions, but they're all approved and adopted by the Florida Association of Realtors and the Florida Bar Association.
Correct. In fact, I sit on the joint committee of the attorneys and realtors that draft that contract.
That's right. I remember I remember emailing you a complaint a while back. Like, why the heck did you do this and this addendum?
Yes.
You actually brought up one more question. As you were talking, it came to mind. A lot of people from out of state, or from other states, I should say, are very accustomed to closing with attorneys. And that while that's not unheard of in Florida, you do real estate closings all the time. I would say 60-70% of real estate closings in Florida happen at a title company. And that's a departure from the norm for a lot of people who've done business in other states. And
correct.
So, I guess my question is, well, what's the difference? And, does the title company have an attorney behind the green curtain anyway? Is there any advantage or disadvantage to closing with a title company versus closing with an attorney's office?
There's no disadvantage to closing with a title agent, provided you understand that title agent can't give you legal advice. They can't help you with the contract. If you need something... Let me back up. The title agent can prepare all of the documents necessary and incident to the issuance of title insurance. They can prepare your deeds. They can prepare whatever needs to be done, releases, things like that. Say you ended up in a property that has a private road and you need a road maintenance agreement because it's being required by the underwriter, and it should be. They can't draft that. You'd have to go out and hire a lawyer. Well, if you already have the lawyer representing you as the buyer, well, you're probably going to close with him if you can, or direct that you'll pay for the title insurance and you'll pick the closing agent who is also your attorney and you've got a relationship, the attorney can prepare those documents. When it comes down to the contract, the real estate agent can only fill in blanks. They shouldn't even draft addenda, other than the addenda that you fill blanks in. They've been approved to fill in the blanks. If you have the attorney, a simple addenda, okay, sure, I'll give you that for nothing here. It takes 5 seconds. Here you go. That helps. There's no additional cost for having an attorney as a closing agent because our rates are set by the state. The title agent charges you the same money the attorney does. There's no difference. The only thing that may be different is the closing fee, and those are negotiable.
Well, that's a great point. And what I hear is if it's a really simple, run-of-the-mill, open and shut, simple, single-family home, easy closing, title agency is perfect.
It's fine. Deed mortgage sat in a platted subdivision, no problem.
Right. But the more complicated the transaction, the more addendums that start to pile up behind that contract. If it's a larger, commercial piece of property, or you're combining multiple parcels, anything out of the ordinary, unusual, you might want to consider closing with an attorney, or
Correct.
at least having your attorney, directly involved in the process.
Directly involved in the closing process, working with the title agency, going, all right, I need to see these documents before they go to closing. Reviewing the documents, double-checking the closing statement, making sure there's no spurious charges. And I'm not saying that people do that, but here and there, you've seen stuff, they shouldn't charge that. Things like that. So things like, even if you're closing with a title agent and you have an attorney, let the attorney look the documents over first.
Absolutely. So for that example investor that we talked about who's sitting at home ready, gung-ho, ready to invest in Florida, they want to create their LLC, they want to have you review their documents, they want to close at your office. Where do they find you? How do they get in touch with you?
You can Google me, John Redding, but it doesn't have to be me. It could be anybody who concentrates in this address.
But for you, it's jrtampalaw.com.
Yeah, www.jrtampalaw.com.
Perfect. So that you now have a real estate attorney in Florida. If you need to reach out to John, he's obviously a friend of mine and a friend of the show. So let him know that you saw him here or heard him here. And John, thank you so much for being here today.
Thanks for having me.
This was outstanding. It's really interesting interviewing an attorney because they only tell you what you need to know and then they stop. I'm used to trying to get people to, well, hang on, let me get a word in edgewise.
We're taught to answer the specific question asked and don't volunteer anything that need not be there.
Exactly, and I could certainly tell that from this side of the table. It's not bad. It's just
It's
just an interesting observation. I'm usually trying to get people to stop talking, but yeah, this was outstanding. jrtampalaw.com. Check out John's firm if you need any real estate stuff, estate planning. You have questions about your insurance coverage. Reach out to John and his team, and they'll find the answers. He'll look them up.
Well, there we go. We don't know them. We'll look them up. But if you had a question, if you wanted to call, that's fine. Give us a call. I'll take calls all day long. And I'm a strange lawyer. I kind of like to sleep at night. If you've got one simple question, I'm not going to charge you to answer it. I'll answer your question. I know you're going to think of that as that's pretty cool. I'm going to use this guy when I need him.
Absolutely. Well, thank you again, John. This was great.
Hey, thank you.
And I hope to do it again sometime.
Sounds good.
Thank you for listening to the Copeland Morgan Media Real Estate Podcast. As you can imagine, producing this great educational content takes a lot of effort and commitment on our part. We only ask one thing in return. Please subscribe to our podcast using your favorite podcast app or by visiting copelandmorgan.com/podcast. And remember, there's no greater compliment than referring us to a friend or colleague. Until next time, I'm Jeff Copeland.